Your parents went to sleep that night feeling relieved, believing they had protected their family. They did what they thought was a smart thing. They found a form online, filled it out, and signed a California transfer on death deed. They were wrong. What they actually did was light the fuse on a legal and financial time bomb set to explode right after they were gone. A bomb that could cost their children everything. In this video, I'm going to show you exactly how California's most popular estate planning shortcut can become your family's worst nightmare. Please subscribe to be notified of our next video, Transfer on Death Deed versus Living Trust in Orange County. The story I just told you isn't hypothetical. This exact problem happens all the time. They thought a simple document would protect their most valuable asset. Instead, it locked up their inheritance, turned siblings against each other, and threw them into the very court system they were desperate to avoid. Stay with me because I'm going to break down the 3 hidden dangers of the transfer on death deed that can strip your family of their inheritance. More importantly, I'll show you the right way to protect your home and your family's future. So what exactly is a transfer on death deed, or TOD deed? Anyway, on the surface, it's an incredibly appealing idea. It's a legal document that lets a homeowner name someone to inherit their property automatically when they die, completely skipping the probate process. No court, no long delays, no expensive attorney fees. Or so the thinking goes. It's like a beneficiary form for your life insurance, but for your home. The process seems easy enough. You sign the deed, have it witnessed by 2 people who are present at the same time and who aren't inheriting the property. Get it notarized and then record it with the county within 60 days of notarization. After that, you still own your own home completely. You can sell it, refinance it, or tear up the TOD deed anytime. The beneficiary has 0 rights to the property while you're alive. For many Californians, this sounds perfect. Probate is a scary word, and for good reason. It's a public, court-supervised process that can be expensive and drags on for a year or more. The TOD deed promises a way around all that with just 1 piece of paper. It feels simple, it feels cheap, and that is the trap. While it solves the one problem of probate, it can create a half a dozen new ones. Let's go back to that family I mentioned. We'll call them the Millers and see how this easy solution turned into a disaster. The Millers, a brother and sister, believed their parents' house was theirs the moment they passed away. They had a copy of the recorded TOD deed. It was supposed to be simple, but when they tried to sell the house to split the inheritance, they hit a brick wall. This brings us back to the first danger of the TOD deed. The Miller siblings found a buyer for the house almost immediately. They were close to the sale and move on with their lives. But then the title insurance company called. The sale was off. And here's why. In California, when property is transferred with a TOD deed, it doesn't get a clean slate. The property is still on the hook for the deceased person's debt for a period of time. Creditors for old credit card bills, medical expenses, anything can make a claim against the estate. The person in charge of the estate can even demand the beneficiary return the property to pay those debts for up to 3 years after the death. Because of this risk, title insurance companies are extremely cautious. After a death, there's a 120-day waiting period for creditors to file claims. But even after that, the lingering 3-year risk makes getting a clean title policy difficult. And without title insurance, no buyer can get a mortgage, which means almost no one will buy the house. The Millers were stuck. Their parents had some unresolved medical bills, and that risk was enough for the title company to say no. They couldn't sell the house. They couldn't get a loan against it. Their inheritance was a paper asset. They had to keep paying taxes and insurance without being able to access its value. The easy deed had effectively frozen their inheritance. As if the financial stress wasn't enough, the TOD deed started a personal crisis. The siblings, Sarah and Mark, started to disagree. Sarah needed her share of the money for her own family and wanted to find a way to sell, even at a discount. Mark, seeing as they were stuck with the house, decided he wanted to move in. This is the second hidden danger. TOD deeds are terrible for co-beneficiaries. The deed just hands over ownership. It gives no instructions, no rules, and no tiebreaker for what to do next. What happens if one person wants to sell and the other doesn't? Who pays the mortgage and property taxes? The TOD deed is silent. And in that silence, grief and stress can quickly turn to resentment. The Millers' only legal option to break the deadlock was a costly and heartbreaking lawsuit against each other called a partition action, where a judge forces the sale. This was the exact opposite of the family harmony their parents wanted. Just when things couldn't get worse, their attorney found the final crushing blow. The deed had been recorded 65 days after it was notarized. California law is brutally strict here. A TOD deed is legally void if it isn't recorded within 60 days of being notarized. With that one tiny mistake, the deed was worthless. The house was now stuck in the very court system their parents had tried so hard to avoid. This is the third danger. TOD deeds are incredibly fragile. A simple mistake in signing, witnessing, or recording can invalidate the whole thing. And here's another critical weakness. You can't name a backup beneficiary. You can't say to my son, but if he passes away before me, then to my granddaughter. If your named beneficiary dies before you, the deed is void, and the house likely ends up in probate court anyway. The entire nightmare, the creditor trap, the family war, the court battle was completely avoidable. So, what should the Millers' parents have done? The answer is a revocable living trust. Don't let the name scare you. A living trust isn't just for the ultra wealthy. Think of it as a private rulebook you create for your family. It's a container where you place your assets, including your home. During your lifetime, you remain in complete control as a trustee. But when you pass, the person you've chosen as your successor trustee simply steps in to follow your exact instructions. A living trust is the superior solution because it solves all the problems the TOD deed creates. First, the creditor and title insurance mess. With a trust, the process is clear and legally robust. Your successor trustee can manage and settle your final debts in an organized way. Because of this, title companies are comfortable insuring the title once debts are handled, meaning your family can sell or refinance the property without a long, uncertain waiting period. Second, The family conflict. A trust is your instruction manual. You lay out the rules. My children have 6 months to agree on selling the house or buying each other out. If they can't, the house must be sold at their market value and the money split equally. No arguments, no lawsuits, just your plan in black and white. And third, the fatal flaws. A trust is a much more robust and flexible tool. It doesn't have the fragile 60-day recording deadline, and most importantly, it allows for detailed backup planning. You can name backup beneficiaries for every scenario, ensuring your property goes to exactly where you want, when you want, and how you want, with ever risking it falling into the court system because of an unexpected life event. The hard truth is that the transfer and death deed is a shortcut that often leads to a dead end. It promises simplicity but can deliver a complex mess of financial risks and family conflict. Your home is probably the most valuable thing you own. It represents a lifetime of work and is the foundation of your family's security. Trying to protect it with a flimsy one-page form is like trying to protect a priceless painting with a piece of plastic wrap. Don't let this happen to your family. The peace of mind you get from that simple form is an illusion. True peace of mind comes from knowing you have a solid plan that protects your assets and, more importantly, protects the people you love. If you're a California homeowner and you want to make sure your family is truly protected, it's time to take the next step. Don't leave your family's future to chance. Click the link in the description to schedule a consultation with our office. We can walk you through creating a real plan, a living trust that will provide true security for generations to come. Thanks for watching. If you found this helpful, a like is always appreciated, and subscribe for more essential information on protecting your family and your wealth.